right, everyone, thank you for tuning in to an episode of Honest Offense. Today, I'm honored to be joined by Ian Rosenberg. Ian has over 20 years of experience as a media lawyer. He has worked as legal counsel for ABC News since 2003. He is also an Emmy-nominated documentary filmmaker and teaches media law at Brooklyn College. On top of all of that, he has an excellent new book out, The Fight for Free Speech, 10 Cases That Define Our First Amendment Freedoms. Ian, thank you so much for being on the podcast.
Thanks for having me. I'll hold up the book too. Thanks.
There we go.
We both got
Synchronized. And it really is. It's a great book. What I love about what you did with the book is that you tie current events in with relevant legal cases and historical cases and First Amendment principles, because that's something I always try to do, because I can get a little fatalistic when I spend too much time in current events. So it's nice to be able to compare it to previous events and previous cases to say, okay, not all of this is unprecedented. We've been through these issues before. We have some foundations for how to deal with these issues. So I love that that's the style you went with the book.
Well, thank you. That was the concept I had from the very beginning, partially from working with media, from communication students at Brooklyn College who are studying media law, and just also for, over the last 4 years and more, people on all sides of the political spectrum are really clamoring about their free speech rights, and whether they're talking about, can Colin Kaepernick take a knee, or what does it mean to have Nazis marching in Charlottesville, or can Trump stop Stormy Daniels from speaking on 60 Minutes? All of those questions are ones I answer in the book, and each chapter, as you say, begins with a contemporary question and then provides the answer by telling the story of the people who fought for their rights all the way up to the Supreme Court. And then that decision really provides, if not the answer, then a lot of context about our First Amendment rights related to those questions. So I both wanted to show how, as you were saying, that the issues that we are speaking of today, there's history we can learn from, and also to use that as a way to say, if you look at these 10 cases, you'll have a great user's guide to understanding free speech.
Yeah. And you're a media lawyer, you're in the corporate world, and I spent a little bit of time in corporate law. Before talking to you, I would have said 100% of corporate lawyers are not interested in kind of the more philosophical principles of the law. So many corporate lawyers are, they're focused on their narrow area and doing what they need to do for their client. Have you always been interested in the First Amendment, in these more philosophical, big picture principles? How did you get into that?
Well, I was a theater major undergrad, and at the University of Wisconsin, and I happened to take a course from Professor Donald Downs, who's one of the country's leading sort of free speech experts, and I just found it fascinating. And so I got into constitutional law. I thought about doing some aspect of arts or media law. I applied to law and theater school at the same time, got into both, but didn't want to be in debt, hundreds of thousands of dollars and have a theater degree. So I went to law school at Cornell and definitely tried to pursue First Amendment law from the beginning. The firm I worked at is Cale, Gordon, and Reindel, and I was lucky to be working with Floyd Abrams, who's one of the country's preeminent free speech lawyers, who argued the Pentagon Papers case and many others. And so, I'm very lucky, but there certainly was a goal to work on free speech issues. And then for the last almost 18 years, I've been at ABC News, which is really a great place to be, and I'm really proud to help support their journalism.
It's funny that you said you went to law school to avoid going into so much debt. That's usually the advice I usually give people who are considering law school. I say, think about something else unless you're willing to go into that kind of debt. But I guess relative to a theater degree, that is the smarter.
Relative to a theater degree, and also I think we're slightly different graduation times. I graduated in '98, and there was still a boom economy where if you did well at a good law school, you could get a high-paying job. Now, maybe it wouldn't be exactly the job you wanted, but it did help me pay off that debt. So I was lucky.
So let's get into the book. So I want to, again, go into that historical perspective. It's interesting that there really aren't any major First Amendment cases before the early 1900s. And I was curious. I mean, we had free speech issues. They were going back to the Alien and Sedition laws under John Adams. Why is it that the Supreme Court really didn't start addressing these issues until, the 1910s?
Yeah, 1919, really, I think. I begin the book with, as you're alluding to, with the Abrams case, which involved anarchist immigrants on the Lower East Side, right where I'm talking to you from, literally blocks away, tossing, anti-World War I leaflets in English and Yiddish out into the street, and then that decision upholding their convictions for essentially sedition, but Justice Holmes and Justice Abrams joining him create sort of our modern notion of free speech in their dissent by talking about the marketplace of ideas. So that's where I begin the book, 1919, and I think most people agree that's sort of the beginning of modern free speech law. Why not before then? I mean, that's a very interesting historical question. I think it is my guess is that there was this tension between, on the one hand, the country was literally founded on revolutionary journalism and on speaking out against the crown, which, in pamphlets and speeches, in newspapers, which was a truly revolutionary act, not just in the sense that they were trying to break away from the government, but also was a radical act. And so that was sort of built into our formation, our origin story as a country. And yet, what did that really mean was very unclear. Did it only mean that sort of the British tradition was that you had limits on stopping publication before they happened, sort of what's known as a prior restraint? Was it only about a prior restraint, or was it something much more than that? And I think the court really just wasn't ready to grapple, and the society wasn't really ready to grapple with that. Even in 1919, the court is still upholding people's convictions for criticizing the government, which you would think would be such an easy, today would be an easy free speech win. There's no way that criticizing the government, even arguably advocating for illegal action, as the Abrams defendants were, we can talk about that more. But I think it was the tension, in short, between believing that free speech really meant something more than prior restraint, but also that was a crazy notion. And I think the courts weren't ready to necessarily embrace that until much later.
Yeah, and let's talk about Abrams and the related case Schenck. So talk to me a little bit about the time, because this has always been a tension in America, right, where we have these freedoms and people have the freedom to speak and say what they believe and propagate these ideas, but people will argue, well, that gives then, communists and fascists and whoever your bogeyman is the power to then subvert the system of freedom. If through using these freedoms, they can gain power and destroy these freedoms. And I think that's the concern back in the 1919s. That's the concern even today. Can you talk a little bit about what was going on back then?
Sure, and I think you're pointing at a really interesting issue that I hope I get at in the book, and I definitely try to, which is that the sweep of sort of whose speech is being repressed keeps changing. So the cases, each contemporary issue sort of jumps around, but the cases I talk about move chronologically throughout the book. You can hopefully enjoy it like a record album, that it all sort of holds together and gives you a framework for understanding our free speech freedoms. But you can also listen to them or read them individually. But who is the speaker or the dissenter that's rights are being repressed definitely changes. So with Abrams, we're talking about a character that I really didn't know about, who is one of the Abrams defendants, Molly Steimer, who I focus on, and I think is just a fascinating revolutionary, feminist, anarchist spirit. She, as well as her fellow defendants, was a garment worker. She had come with her family fleeing anti-Semitism and pogroms in Eastern Europe. She gets to this country. She's supporting her family, working as a garment worker here on the Lower East Side. And she becomes radicalized by how hard her life is, which is, I think, sometimes glamorized in the immigrant experience, or if not glamorized, sort of just tossed over. Yeah, life was hard, but it was very hard. And she was looking for something else. And anarchism really appealed to her. The combination of women's rights and collective sort of support was deeply she was deeply passionate about. Their particular beef was when, in the course of World War I, the American government had decided to get involved on the Russian front, supposedly to defend our allies in Yugoslavia and other places, but most people agree was really an effort to thwart the Bolshevik Revolution. And that was something that, even though the anarchists weren't communists, they were very supportive of the revolution. So when they were putting out these, I sort of shorthand by say anti-World War I pamphlets, but what they're saying was really support the Russian Revolution, don't take up arms against the Russians. And they even said as a PS in their pamphlets, we hate the imperialist forces in World War I even more than you do. And that was one of their defenses. We're not impeding the war effort. We're actually just speaking about one aspect of the war effort. But that all those arguments, people really turned a blind eye to. And as you say, in Schenck, recently, the court had already said that similar anti-war writings could be criminalized, and people could go to jail. Molly was going to go to jail for 15 years, and her male defendants for 20 years each for, as Justice Holmes says, throwing out a leaflet that anyone has as much right to write or read as they do the Constitution. So, their story of being engaged in illegal action is fascinating, and I frame it with a modern question that I did not know would be so relevant. I start talking about Madonna at the first Women's March, saying, "I've thought an awful lot of blowing up the White House," and then she quickly says, "But something like, but I've decided we have to choose love over hate." That didn't stop Newt Gingrich and others from saying that she should be jailed for her remarks. And I say the answer to our questions about advocacy of potentially illegal action go back to the Abrams decision and the test that Holmes sets up that basically ends up becoming the Brandenburg test that defines advocacy of illegal action, which is that you can advocate for something, for violence or illegal action, as long as there is not going to be imminent harm and that is directed to causing that harm. So obviously in Madonna's case, it wasn't directed to causing that harm. She immediately, in the next phrase, said that she didn't really mean it, and there was no imminence. No one at the Women's March was violent, and also how are they going to instantly build a bomb or something and do it even on a practical level? I had no idea that was going to become a defense or woven into the defense of Trump in the second impeachment trial. But it just shows you how free speech questions keep coming up in interesting ways, and we can always gain a lot by looking back at the historical stories that formed these rights.
Yeah, and again, it's always fun to see how those things play out on both sides of the political aisle too. You have Madonna using it as a defense, you have Trump using it as a defense, and people don't understand. I'm glad you made that distinction in the book, because you do that a lot in the book. Actually, you really clarify some of these issues that people don't really understand as far as the nuances of First Amendment. Is that yes, you can actually talk about violence, you can actually advocate violence as long as you're not inciting people to go and do it right now. And so you see, Twitter lawyers all the time. Whenever anyone says anything about violence, people want to have that person locked up, and you make that distinction that no, if they're not actually inciting violence immediately, imminently, there's nothing unlawful about it.
Yeah, and I think, you've certainly talked about on your show before about how people are always sort of like, I believe in free speech, but. Right. So, people are always willing to entertain the notion of restricting other people's speech. But we have to sort of, keep thinking about one of the goals of the book is not just to lay out our rights, which is the primary goal, but for also people not to be wedded to these particular comparisons, to start thinking like a lawyer, the good aspect of thinking like a lawyer, there's some flaws, as you may agree, but one of the good aspects is that you start thinking about problems by comparing them to other examples. And so, people on the left, I don't think they would want Madonna put in jail, or slogans at Black Lives Matter protests, which I participated in, where people say no peace, no justice, or no justice, no peace, or things like that. That could be, in theory, implying illegal action. I don't believe it is, but we have to really, the Brandenburg test and what came out of the Abrams case is a very speech protective test, which is that we only want to restrict speech when there is really an intent to cause harm and very likely cause harm. And I think, in the Trump insurrection case, I think it's a very close call, because we did have violence, and whether Trump was directing that violence, I would argue that he was leading to that. I think we can get into interesting questions of, how do we view the president in that context as opposed to an average citizen? But to the bigger point, I am trying to give people not only the understanding of what their free speech rights are, but when the First Amendment really doesn't apply, and maybe advocacy or change on that action has to come from another source.
Yeah. And again, I think that's a great point. That I do a lot of mocking of lawyers and law school on this show, but one of the great things that I learned or developed in law school is how to kind of extricate yourself from any situation and try to look at things objectively and say, and I try to do this anytime I'm talking with a friend or anyone who has a strong opinion about something going on in politics, or something Trump did, or what Madonna did. And I say, well, if it was the president you voted for, or if it was a celebrity that you liked saying these things, would you feel the same way? Would you want the same thing to happen? And I think that's such an important way to think, is you have to look at these things objectively, because that's the only way we can get to any sort of universally applied rule, is that you have to be able to say, look, I know I don't like this person, but I have to look at this in the long-term picture, that I'm setting a precedent here, and it's going to apply to my side just as much as it is to the other side. So what do I want this rule to be?
Yeah, and that's another thing, I don't call them free speech heroes in my book, because some of them are not good people.
Sure.
But they're all free speech pioneers. And I think that you will, and not just what I think sometimes people traditionally perceive as sort of like the President of the United States or the New York Times, or sort of monolithic institutions. These are, anarchists on the Lower East Side, school children who don't want to pledge allegiance to the flag, another school kid who wears a black armband in protest of the Vietnam War, civil rights heroes, and also, much more reprehensible people like Nazis in Charlottesville. So I definitely wanted to show that there is a sweep of people involved in protecting our First Amendment rights, sometimes for good and sometimes for not so good purposes. But that as a reminder that when people talk about, today, that are Republicans weaponizing the First Amendment or other, accusations from one side or the other, hopefully this cast of characters shows that free speech belief doesn't necessarily fall down on traditional political or party lines.
Yeah. Let's talk about this idea of the marketplace of ideas. And it's a phrase that's been used a lot. I think Abrams, though, that you said was the first time it kind of came up, at least at the Supreme Court. I don't know how convincing that argument is to me. The idea that if you have an open marketplace of ideas, if you just let people say what they want to say and hash it out, that the best ideas kind of rise to the top. And let me know if I'm misconstruing the argument, but to me, there's almost as much as I love the intention of the argument, but it feels like there's a naivety of that argument in that, well, there are times where bad arguments are going to win out if they're just sold really well, or if they do appeal to a specific sector of the population that's going to be active in getting that idea enacted. You will have bad ideas win out. And so how do you feel about the whole argument? Can you first, maybe give a little detail about the argument and how you feel about it?
Sure. So Justice Holmes, in sort of trying to defend the anarchists, I think actually I had a student point out this to me that perhaps he was going with a sort of economic model in order to defend radical anarchists,
Right.
to make
That's interesting.
His defense more palatable or
Right.
seem less crazy or radical. But what Holmes essentially says, paraphrasing, is that the best test of truth is the power to get itself accepted in the marketplace of ideas. And so, the idea is, I think it also ties into the Abrams, location where they were. They were on the Lower East Side. There were these, ghetto markets. People used to call the Lower East Side a ghetto. And there were these markets, and there were pickle sellers, and there were, rag sellers, and there were, repair people, and they were all shouting at you. And somebody might say, those pickles are bad, these pickles are good. And that the person would walk around and hear different things. And they would find the truth for themselves, or at least the best truth for themselves. So let me defend that metaphor and then also sort of counteract it. So one, I do think there's a sort of an intuitive appeal to it. We do have a capitalist system for good and evil, and so perhaps that makes sense. Then our free speech relationship or model should be similar to that. And it is very much focused on taking the government out of the equation, that the government shouldn't be involved in the market. It's not that necessary. So I think people sometimes focus on the truth aspect, which is harder to defend, and less on the let's remove government interference from the discussion in the market, which I think more people can get behind. But another thing that he says that often gets forgotten is that this is again paraphrasing, is that this is an experiment, as is all life an experiment. And it's an idea that I love, that Holmes isn't saying this is definitely always going to work. He's saying that, like an experiment, sometimes it works, sometimes it fails, but just because your test on a vaccine fails in one part, that doesn't mean that's not helpful information, or that you have to abandon the experimental model. So that's sort of the best arguments I think that on a quick level that you can make for the marketplace of ideas. The worst arguments or the best attack on that model, I do try and bring up in the book, and one of the things I try very hard in the book to do is to not to say our current system is always right, and sort of brush aside the critiques. There are very powerful critiques of the marketplace of ideas from critical race theorists and equity theorists and others, and they basically boil down to this. First of all, who is excluded from the market? For outrageously long periods of time, Black people, women, some religious minorities have been excluded from the market. And how can we have a marketplace of ideas if we're, cutting out basically more than half of the population who can participate in that market discussion? Secondly, what about economic power? As you're also pointing out, if you have if you can pay for a bigger megaphone, you can pay for advertising, you're going to have more influence in the market. And do we want, the quest for truth to be so tied to corporate power or economic power? And then someone like Catherine McKinnon, who's a feminist legal pioneer, has a very eloquent line where I'll paraphrase again, and she says basically, has the truth of the Klan, or has the speech of the Klan ever uplifted the speech of Black people? Has the speech of Nazis ever informed the speech of Jews? Has the so-called speech of pornographers ever helped the speech of women? No, she says. And it's a very compelling answer. And so I think these are all, there's so much academic discourse about why the marketplace of ideas does not work. And a lot of it is hard to argue with because it is so compelling. But you cannot be engaging in a discussion about free speech at sort of almost any level without understanding this metaphor. You don't need to embrace it. You don't need to accept it. But what I'm trying to do is say, like, okay, Chapter 1, we're going to start with the key metaphor for basically all of free speech law. If you read anything, if you read nothing else and you read Chapter 1, you're going to already be able to engage in any kind of cocktail party debate you want about free speech. And so I do think it's necessary, even if it's problematic in many ways.
Yeah, well, but I think you made a good distinction too, because there is you can make the analogy to economics that there is a utopianism to capitalism, the way that some people talk about, in that just, if you have a free market, everything's going to be great, and just the best ideas are going to win. The people who make the best products are going to get rich, and you can do the same thing with this marketplace of idea, which is, if you let everyone talk, then the best ideas are going to win out. But you have to look at it realistically and say no, not all the time, that the best thing isn't going to happen every single time, but through this process of experimentation, the idea is that there will be good ideas that are able to rise out of it, and it's better to kind of have this chaos of freedom than to have some higher power tell you what the good ideas are or what the good products are.
Right, because ultimately then who will decide?
Right.
And that's sort of, along with the marketplace, the sort of ideas, a concept, the sort of who will decide thing. I don't think anyone who was a Democrat or liberal would have wanted the Trump administration defining what was truth in the marketplace or anywhere else. And perhaps conservatives feel that about the Biden administration. At the end of most of my book is descriptive. Essentially, all of my book is descriptive rather than prescriptive. But in the afterwards, I do have a few sort of maxims. I say pieces of guidance to consider free speech concepts in the future. And one of them is expand the marketplace of ideas. So just because you believe or willing to accept that metaphor doesn't mean you have to sort of say, well, there's nothing we can do. I think there's a lot of things that we can always do in legislation or in activism to try and make sure that the marketplace is as open as possible. And then the metaphor works much better.
Yeah. And I'm glad you brought up the idea of being descriptive as opposed to proscriptive, because I was going to talk about that. One of the other things I really love about the book is exactly that, is that today it feels like, if you're talking about anything related to current events or politics or law, everyone's left, right, center, libertarian, whatever, everyone's trying to tell you what to believe. And I think people are sick of that. It feels like you're being talked down to. It feels like you're being told what to believe. I love your approach to this book, because it is just about, hey, here's some current events, here's some historical examples that are relevant to this current event, and you can make up your own mind. You're not telling people whether to support these anarchists and their petitions, or you're not telling people to believe any of this. You're just saying, hey, here's what happened, here's how it's relevant, and make up your own mind. I love that.
Well, thank you. I'm glad that worked for you. I mean, even just talking with you for a few minutes, people might see that I have opinions. I obviously have lots of opinions and have a political point of view, but I did very much try and have the book be about describing, controversies that we all are talking about from all sides, and then present the case that really answers what the Supreme Court says about this. So essentially, what is our law today? And I want people to be able to be sort of armed with the knowledge that they need to argue either for or against, I hope sort of for pro-free speech doctrine, but this book is designed for that people to have the user's guide they need to make the arguments that they want to make, whether they are an activist, somebody tweeting about a cause on Twitter, or just a concerned citizen. And I think that so many books out there about the First Amendment this is my take on the way the First Amendment should be, and unless you really love that person or already agree with them, I don't find those books that interesting. So I was trying very hard to make the fight for free speech be about today and history, and then you the reader can fight for free speech every day as a grassroots activity.
And I try to take the same approach with the podcast. Is if you listen to me, you know what my opinions are going to be on things, but my goal isn't to make everyone believe what I believe. My goal is to have interesting people on who have things to say, and respect the listener and the audience enough to say, hey, you guys make up your own mind. I'm not going to sit here and pretend to be objective, because I think there's something I don't like that. I don't like people who try to act like they don't have an opinion. So I'll tell you what my opinion is, but I'm also going to present the other side, because I think that's important.
Well, I totally agree. And I say in the introduction that, one of the things I've learned from my career of basically always talking about complicated free speech and free press concepts to smart people who aren't lawyers. So that's my job. And so that's the approach of this book, which is that we can ditch jargon and academic theory and law school type citations. And although there's a lot of endnotes in the book if people want to delve into it, but I try and remove them from the flow. We can ditch all that, and that wisdom can be condensed, and it doesn't need to be dumbed down. And so that's the goal for this book.
Yeah. I want to talk about Schenck and fire in a crowded theater, because that's a phrase everyone's heard. No one really knows the context of it, though. So I wanted to get into the context of what it means that to say you can't shout fire or falsely shout fire in a crowded theater. And that was Holmes that wrote that. And what was he applying that to?
So, when Holmes is talking, so Holmes is basically saying there are limits on speech. And one of the interesting things about Holmes is that he really evolved. He did not start out as a champion of free speech. And there's a great book out called, I believe, The Great Dissent, which I use as source material in the book. And it talks about Trump's evolution, sort of intellectual evolution from a relatively conservative who served in the Civil War, and basically he had a phrase that was like, basically my country right or wrong, is what he had said at one point, to really protecting dissent and being a champion of free speech by the time of Abrams. And that's sort of the pivot for him. But in Schenck, he rules with the majority and restricting speech, and in sort of explaining why in some circumstances he can limit speech, he says the fire in a crowded theater metaphor. But I'm glad to have another chance to talk about why people misunderstand this metaphor all the time. Because we say, people say I'm for free speech, and they always will add to that, almost always will say, well, you can't cry fire in a crowded theater. But the quote from Holmes, which is crucial, is that you can't falsely cry fire in a crowded theater and cause a panic. So, because if you're saying it's something that's true, of course, if you see something, say something. If there's fire, you're going to get a medal for crying fire in a crowded theater. And if you say fire, fire, and somebody goes, no, don't worry about it. It's a smoke effect for Act 2. Oh, nobody's harmed. Okay, fine. There's no harm. That's not a crime either. So falsity and harm should always be, they're not necessarily the deciding factors, but they should always be factors when we're talking about the potential to limit speech. And people just skip over that and say this metaphor means, or this expression means that we can always restrict speech basically at any time. So I say, if you're going to learn nothing else, learn about the marketplace of ideas. Even more so, if you're going to learn nothing else from this podcast or from this book, please use the falsely crying fire in a crowded theater and causing a panic metaphor correctly going forward, and you'll already be way ahead of the game.
Right. Good. Yeah, I wanted to clear that up, so I appreciate that. I could go through this book chapter by chapter. Every case, everything you talk about in it is excellent, but I'm going to jump forward. I want people to buy the book. I'll jump forward to the Pentagon Papers case, and because this is another one of those big areas where people say, I believe in free speech, but when it starts to jeopardize national security, that's when there's a problem. So can we talk about the Pentagon Papers? And I'd like to compare them to some of the more modern, Edward Snowden and Julian Assange, and because I haven't really seen, and I don't think you talk about them in the book, how their situation is similar or different from the Pentagon Papers situation.
Yeah, I'd be happy to. But the way I frame it in the book is to it's a little bit in the end notes, but the way I frame it in the book is that we're talking about when Stormy Daniels appeared, or tweeted out, her lawyer tweeted out that she was going to appear with Anderson Cooper on 60 Minutes. At the time, first everyone was like, "What is she going to say?" And then shortly after that, people were like, "Oh, is she going to be able to say it? Because is somebody going to stop her from speaking because she complicated but was involved in this NDA with the president in a non-disclosure agreement, basically a contractual bar. I know but a contractual bar that prevents people from speaking about a particular circumstance. And would the president of the United States, which there was some effort on his legal team, didn't come to fruition, to try and stop her from speaking. And I say that the answer to the confidence that Stormy Daniels and 60 Minutes and the president of CBS News, actually, there was enough rumors that he had to sort of at a press conference had to say, this interview is definitely going forward, we're just working on it, is because of the Pentagon Papers case. We can talk about WikiLeaks and other leaks in a minute, but in the shortest version, it's I think, you know, the great First Amendment battle of our time, of past time, and you know, Daniel Ellsberg, this very unlikely rebel who served in Vietnam War and advised people like Kissinger and was working at the Rand Corporation, and actually was a co-author of the Pentagon, one of many co-authors of the Pentagon Papers case, which was a historical review of America's involvement in Vietnam as Robert McNamara became, the then Secretary of Defense, became disillusioned with the war and wanted sort of this comprehensive, encyclopedic, ridiculous multi-volume look into, I was going to say expose, but look, top secret look into the war. Ellsberg becomes also radicalized about the ongoing conflict, felt like it was something that couldn't be won, and tries to leak the papers with little success, actually, until he gives it to the New York Times, who takes it in, spends a lot of time reviewing it, and starts publishing it. But you know, today we sort of will debate about, was this leak okay, was this leak not okay? But it feels more sort of philosophical, not legal. Everyone sort of accepts that leaks happen and the press reports on it. But at the time, it was an incredibly radical notion, so much so that the Times fires, the New York Times fires, excuse me, they get fired. They get left at the altar by their law firm, Lord, Day and Lord. You couldn't come up with an old white shoe name like that if you saw it in a movie, but Lord, Day and Lord drops them because they say, not only do we not support you publishing this top secret documents during wartime, you as a publisher might go to jail, and we're not going to support you. So they bring on a young lawyer named Floyd Abrams and his partner, a law professor, Bickel, and they argue on behalf of the Times, and I talk about how I do a lot of the oral arguments in a condensed version in the book, and I think oral arguments at the Supreme Court are really fascinating, particularly because so rarely do you have so many smart people who are really just trying to tease out different elements of how to interpret a law in sort of practical language. And when you strip out, as I do, sort of the case citations and the procedure and some of the hesitations and the back and forth, you can get an incredibly compelling narrative. And what happens in the oral argument is Bickel is pushed to say, are you saying under all circumstances that if there was loss of American lives, that you would still say that the Times has a right to publish? And he says, well, I don't believe there is any likelihood of loss of American lives in anything that's been published. And he says, no, you have to answer the question. And Bickel says, yes, in some circumstances, I believe that even the First Amendment right to publish information would be trumped by, basically immediate and direct loss of life or harm to American forces. And the ACLU was outraged about that. One of the other justices says it's a pity that the Times couldn't find a lawyer that actually believes in the First Amendment. But I believe that's why the case turned for the paper. And so the Supreme Court holds that even top secret documents during wartime, unless there is a direct and an immediate likelihood of danger to the nation, that type of publication must go forward. Now, they also said that people could still be criminally penalized for that publication. And another running theme of this book is that just having free speech rights doesn't mean freedom from consequences. And that was the ultimate consequence. Ellsberg, the New York Times has, and later the Washington Post have a right to publish the Pentagon Papers, but Ellsberg was prosecuted again for essentially espionage, and probably would have been convicted had not Nixon overreached and bugged his psychiatrist's office and broke in and did all the things that led to Watergate. So Nixon wasn't undone by the Pentagon Papers. He was undone by his paranoia and his efforts to get Ellsberg. So Ellsberg's case is dropped. And what the takeaway is for today is that if you can publish top secret documents about the war during wartime, you certainly should be able to have Stormy Daniels speaking, despite the fact that you might have an NDA. Now, when I wrote the book, Trump hadn't made an actual effort to stop publication of a document. But when the book was in its final stage, and I was adding in a few notes about this, he did try and stop his family tried to stop his relative Mary Trump's book, and his administration tried to stop the Bolton book. So we then have examples of actually government efforts to stop publication of critical information, and the Pentagon Papers is once again the key case and the key reason why those publications should go forward. Now, to get to your initial question about how is WikiLeaks or other leaks similar, I believe in the shortest answer that they are similar and they should be equally protected. Some people, like Floyd Abrams, who was the lawyer in the Pentagon Papers case, are a little more circumspect and are concerned that what the Times did was they took in all the material, they reviewed all the material, they spent like a month actually holed up in a secret hotel room, going over the material to check for accuracy and also to check that it would not harm American lives or troops or impede the broken down peace process. And WikiLeaks and other sort of dumps of information aren't necessarily serving in that journalistic function. And there have been claims that there was threats to individuals because of it. It's a little bit of a tougher call, but I ultimately think that yes, we absolutely need to treat the subject matter of what's happening, leaks about government misconduct, rather than the format of how it's happening, the press versus a website, or right. or the mainstream media versus online distribution.
And do you see any fundamental difference between what Edward Snowden did and what WikiLeaks and Julian Assange did?
I think there are differences. I think Snowden was more circumspect, and that WikiLeaks was more of a complete blanket dump, and so I do circumspect both in what he was trying to put forward, and there was also greater indication of absolute illegality in terms of illegal wiretapping or illegal surveillance of American citizens without sufficient court authorization. But I think he's a better test case. Right. But I still think it is hard to start cabining what it's hard to say that one of them is protected and the other is not without eviscerating the protections. But once again, even the Pentagon Papers case says that there is a right to publish this material. That does not mean there is a right for the people who violated, protocols or national security laws to release this material. They can still be prosecuted. And even though I might personally find that problematic and think that there are better people to go after, it is not inconsistent to say what the Pentagon Papers case protects is the right to publication, not the right to be immune from consequences.
I was so disappointed when Trump didn't pardon at least Snowden, because I thought he loves sticking his finger in the eye of the institutions, and here's a way to do it for some good. I mean, this was a guy who was prosecuted by the Obama administration. Like, I thought it'd be such a good move for him politically that he would see that, and we could at least get some good out of his administration at the end there. It was so disappointing. But
well, I think, Trump is never going to align with dissenters. He's even conflicted about when, aligning with dissenters who sort of support him sometimes. So that wasn't entirely surprising to me. And it is one of the great black marks on the Obama administration in terms of free speech perspective. Is that the Obama administration was, more active in prosecuting leaks than any other administration in history. Now, he didn't have the sort of combined antipathy to the press that Nixon and Trump had, but it is still inexplicable to me. I've never been able to wrap my head around it, how Obama, the constitutional law professor and a friend of the press, was behind those prosecutions. I have not heard a good explanation other than sort of he was. I've not heard a good explanation. But
I haven't either, and this goes back to kind of thinking like a lawyer and trying to look at things objectively. I think Obama was just as much a threat to freedom and free speech and the First Amendment in different ways as Trump was. I mean, not just leakers, but you look at people like Aaron Swartz. I did a podcast about him with Lawrence Lessig, and he was a kid just trying to make information available to people, and the Obama administration prosecuted him. And you look at someone like Ross Ulbricht. There's a lot of complications in the Ross Ulbricht case, but again, same idea roughly, where he's trying to kind of promote. He's an idealistic kid, and the way they swung the hammer down on him, that's another disappointment with the Obama administration, the way they handled a lot of these cases.
Yeah, I'm not. It is a disappointment. I am not going to agree that I'm going to push back and not say that there is an equivalency here.
Okay.
There is no equivalency in my mind, between the Obama administration and the Trump administration in terms of free speech issues or free press issues. And one of the other reasons, now I'll use this as a segue, is one of the other reasons I wrote this book is that we've had 4 years of being told that the media is the enemy of the people. And going back to what you said before, I'm not objective. I work for the mainstream media, but I also have the privilege of witnessing firsthand how hard people at ABC News, and I believe at other mainstream organizations, worked to get things right and to tell people what they know and the truth and what they need to know. But we were continually told by Trump not only that the media is the enemy of the people, but the idea that the media can lie and get away with it, and that is not what our libel standard is. And I talk about that's the contemporary issue I use to discuss libel in my book, and then I segue into how the case that informs our libel law to this day is New York Times versus Sullivan, which is really about Martin Luther King and other civil rights defenders. And their speech, and we have them to thank for the sort of balance of the actual malice test that we have today. So I do think there are big differences, but even though there were problems with the Obama administration,
we can agree to disagree on that. Yeah. I want to turn to something a little more fun. You were talking about oral arguments, and you do a great job of putting in these excerpts of oral arguments that are great. My favorite one is Cohen versus California, which is the fuck the draft case. And it was just so funny reading the justices kind of giggling at, is he going to say the word fuck at the Supreme Court? And the lawyers kind of joking about, they're going to throw me out if I say it. Can you talk a little bit about what was going on there?
Yeah. So I begin this chapter with talking about the woman, Julie Briskman, her name later came out, who flipped the bird at Trump's motorcade, not realizing that there was a reporter in the caravan who took her picture. It went viral. Stephen Colbert talked about, long may she wave. And she gets fired from her job, actually, because of it. And we can talk about how sort of private employers can generally restrict people's free speech all they like. But I say that there is a right to offend, and it comes out of the Cohen versus California case. Cohen was a young guy who was appearing in California court as a witness in a different case, and he had on a jacket that said on the back, "Fuck the draft." And this is during the Vietnam War. He's arrested for essentially disturbing the peace, even though there was no peace disturbed and nobody objected, and they mentioned it to the judge, and he said, "I don't care." And then the police arrested him outside anyway. And he was going to spend 30 days in jail. And this case goes up to the Supreme Court, as you say, and Professor Nimmer, a noted copyright expert, but also speech expert, ends up being his lawyer. And he became convinced in his strategy from the oral argument that if he did not say "fuck the draft" in his description of the case, that it would make it seem like the word was so powerful and dangerous that it should not be said in the courtroom like in Cohen, and that he would lose his argument even if everything else went well. So the Chief Justice tries to skirt over that by saying, "We're well aware of the facts, Mr. Nimmer, just, jump right in." And he avoids that and says, "Well, thank you. I'll only be briefly about the facts." And he then describes how he wore a jacket that said "fuck the draft," and he does, as you were saying, he tells his son later that he was afraid he was going to be taken away in handcuffs. And people on the court were outraged. Chief Justice Space supposedly got beat red. There was a whole discussion about one of the justices what if his wife heard this oral argument and heard that word, and people were like, "I think it'd be fine if she heard that word." But the court ultimately says that there is a right to offend. Justice Thurgood Marshall in the oral argument, pushes it back and says, what is it? What is the action that you're supposedly? What is that involving this disturbance of the peace? And he gets the lawyer for the state to basically say, no, it's the word. Sort of doesn't even realize he's made a colossal admission. And so the court says that there is a right to offend, and in beautiful language, one man's vulgarity is another man's lyric. And so, there is a right, not on television, broadcast television, which is another case I talk about.
We'll get into that.
But, but there is a right to curse. And even more importantly, there is a right for speakers to express the emotive value of what they're saying. Not only are visuals part of speech because he didn't actually speak it, it was written, but also just saying, I disagree with the draft would not have conveyed the message that he wanted to express. Right. And that's another one of my maxims at the end of the book, is that we should allow speakers the freedom to express their messages as they choose, because really otherwise we're not allowing expression at all.
Again, I want to get into every single one of these cases with you, but I know we have a limited time. So the last case I want to talk about is FCC versus Pacifica, because it involves George Carlin. He's one of my heroes. You didn't like to use the word hero in the book. I will call George Carlin a hero of free speech.
Yeah, I'll go with Carlin as a hero.
Okay. And on this podcast, we've talked about Lenny Bruce, who is Carlin's hero. I talked to Kelly Carlin, who's George's daughter. And George very much believed in the principle of free speech. He wasn't just some guy who's just going off and talking and not knowing what he was doing. He was very thoughtful in what he did. So can you talk a little bit about the background of that case and what was going on there?
Sure. So I talk about the Carlin case. I begin with the contemporary question of why can Samantha Bee call Ivanka Trump the C word and seemingly get away with it, and what are our speech protections today? And it does all boil down to George Carlin and his 7 dirty words monologue, essentially, where he was also Lenny Bruce was also his idol, and he talks about how Lenny Bruce was the first person to talk about free speech in his act, and he was destroyed because of it. I was the first person to do it and become a success. I'm paraphrasing there, sure. But So he has this, great monologue, which you can listen to online, where he, talks about the 7 words that you can't say on television. And the whole monologue is clearly, besides saying the words, is riffing on the foolishness of language and why are some of these words bad and other words not. He says there's so many words in the English language, but there are 7 you can't say. Those must be really bad words. I'm starting to lapse into a poor impression.
I was going to say that's a pretty good impression. That's not too bad.
Thank you. It's the tone is a little bit right. So anyway, it's he was compared to Mark Twain and others. He is satirizing language. He's poking at the counterculture, or he's part of the counterculture, and he's poking at dominant culture. It's literally a monologue about free speech. It is not just a cursing incidental to his act. And one person complains. One dad whose son was really like a teenager and who was involved in media morality, so it was not just some random dad. Complains when he hears this monologue on the public-supported WBAI radio and files a complaint with the FCC. And for the first time, the FCC tries to restrict content based on cursing, basically, based on language. And when it goes up to the Supreme Court, Justice Stevens, in a poor decision in my mind, basically says that this is like an assault. That you can't just say turn the channel because you've been TV and radio, so then new mediums. Today everyone's talking about social media as the mediums of choice, but then the relatively new mediums of TV and radio. At you in your home, you don't know what's being said, and what can parents do and what can other people do, so that the FCC is constitutionally permitted to regulate, if not entirely censor, content based on language. And then through historical anomalies, that has applied to broadcast television, but not radio. But not cable. Applies to broadcast radio and broadcast television, but not cable. It's a historical anomaly that I don't think makes any sense anymore, but that's why Samantha Bee can say whatever she wants, or you can have the Bada Bing Club on HBO, and you won't see that on network television. And Carlin was very philosophical. Justice Brennan has a great dissent, and he was like, yeah, Brennan, us Irish guys stick together. But he also says that he enjoyed being a footnote in American law. And he's really more than a footnote. I think you and I will agree that he is a hero and a champion, and somebody who sort of triumphed even when the case went against him, because most of all of the book, except for this element, is explaining the rights that we do have, but there is no right, much as I might disagree. The Constitution, the Supreme Court has repeatedly upheld the constitutionality, as recently as the Janet Jackson cases and others, that the FCC has the full power to regulate both fleeting images of nudity and fleeting curse words into the late night or early morning hours.
Yeah. And it's so true what Carlin said is that he found success doing what he did, whereas Lenny Bruce was really more of a tragic story. And again, if you guys are interested, go back and listen to the podcast I did with Ron Collins and David Scover on Lenny Bruce. It's so important to understand this history, because you do have to realize this stuff doesn't happen in a vacuum, that George Carlin had to build on Lenny Bruce, and Lenny Bruce had to go through everything he went through to have a George Carlin, to now have the current state of comedy and this flourishing of speech. And so again, what you did with the book, it's beautiful. I love it.
Thank you.
I want to ask you about social media before we go, because it is such a, I feel so torn. I still don't know how I feel about where to go with social media and what the law should do in regards to social media. I am very much a free market person, where I say I don't like the idea of the government coming in and telling these private businesses what they can do with their platform. No. It does also make me very uncomfortable that these platforms do have so much power, particularly in this past year when everything else was shut down, I mean, there was no public square. You legally couldn't go in the public square. All you had was these platforms to be able to express your opinions, to be able to discuss current events. And that's really where all of that stuff is happening. It makes me very uncomfortable that these platforms do have the ability to just say, we're just going to erase people. And the way they do it at times, too, where it's across every single platform within a 24-hour span, they'll block someone. That makes me very uncomfortable. I don't like the concentration of power, whether it's government or private. I don't know what the solution is. There's no solution that I feel like I'm comfortable with this from a principled standpoint, from a legal standpoint. How do you feel about the whole situation?
Well, I think this is definitely the area today. I mean, maybe hate speech is one area where our current First Amendment standards are so troubling. I ultimately believe the court's approach is the right one, but deeply troubling. But and also particularly unsatisfying, I think, in the social media context, because it's so new and the court's review of the issue is so limited. So my book begins with a case from 1919 with Abrams, as we talked about, and the last case in the book is 2017, and that is really the Supreme Court's first and only significant discussion of social media speech. It comes about in a case, Packingham, which involved a sex offender in North Carolina, who posts on Facebook about a traffic ticket and is a very studious police officer tracks him down and arrests him for violating this law that prohibited sex offenders from having any access to social media whatsoever. And when it gets up to the Supreme Court, much as this is a very distasteful person, Justice Kennedy, in one of his last significant opinions, says sort of what you were saying, that, although this is a relatively new medium, maybe not so new, but that social media is relatively new by constitutional standards, it is like the town crier on steroids. It is like the public forum or the public square brought into the vast democratic forums of the internet. And so that now everyone has this ability to speak where they couldn't maybe in real life, particularly as you're saying during our pandemic times. And the court holds that perhaps something narrower could have passed constitutional muster, but that there is a First Amendment right to access to social media. And so that so that's the only thing the court has really made clear. And even though the court makeup has changed since then, I still believe that this court will continue in that tradition. So we have a right to social media to access it, but that does not answer, and that's where I think your discomfort comes from, all of the sort of big questions about speech that are left. But I do then go into sort of explain that, to remind people why this doesn't answer the big questions. And that goes back to, again, the private sort of government distinction that we're talking about. Private companies like Twitter and Facebook and YouTube do not have to follow the First Amendment. The First Amendment, as you well know, says Congress shall make no law abridging the freedom of speech or the press, and Congress has been applied to the federal government and the state, but that's it. And so there is no question constitutionally that social media companies have a right to kick anyone off, including the President of the United States, to take some ads but not others, to label content as misleading or inaccurate, to provide follow-up links. That is all constitutionally permissible because they are private actors, and in fact are sort of expressing those companies' speech rights in their editorial discretion as they move forward in controlling what's on their platform. So I don't want to say that therefore we throw up our hands in the air and go, constitutionally, there's nothing we can do. Let's just, focus on a different problem. I just think this is one of the areas where the First Amendment is not going to be the tool to make change. So, I think there's a lot of things that we can do. Sacha Baron Cohen has attacked, what he calls the Silicon Six, and that's how I begin the chapter. The leaders of social media companies for not doing enough to prevent hate speech. And I think he and others have been successful in getting more to be done, not maybe, certainly not as much as he would like or other advocates would like, but lobbying and public sort of aggressive criticism can make change. We could, one of the great flaws with social media companies is their lack of transparency about how they're editing or controlling the speech that's on their line, and I think it would be potentially constitutionally, not potentially, I'm gonna actually just say it. I think it would be constitutionally okay to say that we could have laws that require greater disclosure from social media companies about their policies, and that's not everything, but at least if we knew what the rules were, we could advocate about those rules and make sure that they're applied fairly. So I think there's a lot of reason to be frustrated and sort of not feel like the court is doing enough here. And I don't think that the court is going to change, and I don't think that regulating the social media companies as a public carrier, like telephone companies, even if that is a good idea, I don't think that's ever going to happen. The court has sort of, in a related case about cable TV, public access TV, and sort of dismissed that possibility. So I don't think it's going to happen. So I think if we want to make change on the way social media is used and applied, then we have to do it through advocacy, and that's hopefully another takeaway that people will get from the fight for free speech.
Great. Well, Ian, again, I could keep you here all day. There's so many great cases. I mean, there's the Falwell versus Flint case, one of my favorite.
One of my favorites, yeah.
Two of the best personalities in American history. And again, the way you write about it, the book is The Fight for Free Speech. It really is a page turner. I've never said that about a legal book before, but if you're interested in
nice.
in free speech, in the First Amendment, I recommend this for everyone. If you're a lawyer, you'll get a lot out of it. If you're not a lawyer, you'll get a lot out of it. Ian Rosenberg, thank you so much for your time. Is there anywhere else you want people to find you?
Well, they can find me on thefightforfreespeech.com is my website, and I'm on social media for good and ill on @FreeSpeechBook. And one other exciting thing is that coming out in November, there's going to be a graphic novel adaptation of The Fight for Free Speech from Macmillan First Second. That's called Free Speech Handbook, and there's an amazing illustrator, Mike Cavallaro, who's really brought these images, these metaphors and images to life.
Oh, that's so cool.
I hope people will check that out when it comes out on November 2nd.
Absolutely, and I'll share that link when that comes out as well. Ian, again, thank you so much for your time.
It's been fun, Eric. Thanks for having me.